Our next matter is Charles Kratovil versus City of New Brunswick. May we have appearances, please?
Good morning. Alexander Shalom from Lowenstein Sandler, along with the American Civil Liberties Union of New Jersey. I represent Charles Kratovil.
Good morning, Your Honor. Frank Corrado. I'm here for several friends of the court, the Reporters Committee for Freedom of the Press, and several media organizations, Gannett, the Media News Group, the New Jersey Press Association, and New Jersey Advanced Media.
Good morning, Your Honors. Susan O'Connor, Hoagland, Longa, Moran, Dunstan, Dukas. I represent the defendants, City of New Brunswick, and former Director Kratovil.
Good morning, Your Honors. Michael Zuckerman on behalf of the Attorney General as amicus.
Thank you, counsel. If we don't finish the argument by 12:30, we'll take a half-hour break at that time. Mr. Shalom.
May it please the court, if I might reserve 2 or 3 minutes?
Sure.
Thank you. This case asks a simple question about whether the government can provide information to a reporter and then later attempt to punish the reporter for reporting that same information in a story about an issue of public concern. It cannot. I'd like to do 3 things in the argument today. First, I'd like to talk about how the lower courts erred in their analysis of whether or not the matter was one of public significance. Then I'd like to go through the other elements of the Daily Mail test, whether it was true and lawfully obtained. And finally, I'll apply the Daily Mail test to decide whether there is a need of the highest order and whether the law is narrowly tailored to achieve that purpose. Before I get to those 3 points, though, I'd like to talk about what this case is not about. This is not a facial challenge to Daniel's Law. It does not ask whether there are any conceivable constitutional applications. It simply asks whether it is constitutional on these peculiar facts. The case also does not question whether Judge Salas and her family have suffered greatly. The case does not question whether Judge Salas has fought heroically in her son's honor. And the case does not question whether the government may do something to try to keep judges and other public officials safe. The answer to those last 3 questions is unequivocally yes, and Mr. Kratovil has not challenged that finding at any point in this litigation. With that said, I'll start with the question of public importance. The law on this is very straightforward. The courts have been crystal clear that the test is whether or not the contested fact concerns a matter of public interest, whether it involves a matter of public significance. In other words, the test is relational. The lower courts and the city and the Attorney General take a different view. They take a necessity view. They want to ask whether the particular fact is necessary or whether it's superfluous to the story. But that is not what the United States Supreme Court has done in any of the cases. And I should say, they're also wrong as a matter of fact about whether or not this is a matter of public concern. The Attorney General proposes that we ask whether there's any residual public interest in the matter. And the appellate division says, well, we have this common sense solution that will work for everyone. Mr. Kratovil can just say what city the director lives in and no more.
So how far does that go, Mr. Shalom? Let's say there is a organized crime trial, and it's presided over by a trial judge. And the reporter, for whatever editorial reasons, wants to say, Judge Smith was the trial judge, and he lives at 124 Main Street in town X. Now, he's the trial judge. It has his residence is part of his persona. It's part of his existence. Does that fall within the definition as you claim it should be applied?
So that need not fall within the definition. If I might explain where I think the court is bound. In the Florida Star, the court said, look, we're not going to ask about the specific fact. We're going to ask about the issue generally. They rejected the idea that we're going to look fact by fact and instead kind of imposed this relational test. Now, sometimes
obviously a very distinguishable situation, Florida Star.
Sure, every case is decided on its own facts, and particularly that one.
Understood.
What we,
But please go, just,
I'm going to answer your question directly.
okay.
Sometimes the nexus between two things is, yes, they're theoretically related, as you just described, right? It's part of who the judge is, but not really an intimate part of the case. But when the nexus is at least as close as it was in the Florida Star,
But you're taking a very broad view of what related means in your brief. It is so why is it that address could, I think you're arguing, could potentially be required to be withheld from that article when you're also telling us not that it's inappropriate for courts to look into the purpose of an article and essentially become what you would say is an editor. Why is it that if Mr. Kratovil is right in this case, that a reporter could not gratuitously put a judge's home address into every article that involves that judge?
so let me try and take your question in two parts. The first is on the, does my brief take a broad view? In my brief, I cite to a series of cases that do take a broad view about what it means to be related to. And then I say, and the court need not adopt that view. All the court needs to do is say that the relationship between Director Caputo's home address and the distance he lives from his place of employment, that the nexus between those two is at least as close as the nexus that was found sufficient in the Florida Star. So in the Florida Star, the issue of public concern was crime, violent crime, and rape. And the specific fact was the name of a particular victim. And the court found those two things sufficiently related. And here what we have is the distance that Director Caputo lives from New Brunswick, everyone agrees is a matter of public significance.
Let me refine the hypothetical. Let's say the hypothetical is that the judge has been threatened and there's a charge for threatening a judge. And the reporter decides to include the judge's home address, perhaps to indicate whether it's really a geographical location, in which the defendant could likely have committed some violence, just for whatever reason. That seems to have some nexus to the charge of threatening to come to the judge's home and do harm. So is that address within the scope of your rule?
That becomes a closer question, but let me be very clear. This is an as-applied challenge. I'm not asking for a rule. I'm asking for permission for Mr. Kratovil to write the article that he intends to write.
But even in an as-applied challenge, there is a request for a rule.
And what I'm suggesting is there are courts out there that have taken a capacious view of what a matter of public interest is as it relates to home addresses, and the court need not go that far. It only need go as far, and in fact, it must go as far as the Florida Star went. And so if you find that the nexus between where he lived, the distance between his home and his work and his actual address, if that nexus is closer than rape in general and a victim's name, then the Florida Star mandates that my client have that the Daily Mail principle applies, and we get to steps 2, 3, and ultimately the narrow tailoring.
Just Shalom, your brief and those on your side put a lot of significance on the decision making of a records custodian. We have 500 or so municipalities in New Jersey, 21 counties, a
School boards,
number of state agencies that have people that on a full-time or part-time basis perform the role of a records custodian. As I understand your side's position, that you read the case law, First Amendment case law, that if it's lawfully obtained from such a records custodian, either you're entitled to publish it or you have a very strong First Amendment interest in publishing. But systemically, I'm wondering, bearing in mind some of the things this court said in Gannett Satellite about the training and qualifications of records custodians, does it make sense to place in this case or other cases so much significance on what a particular records custodian decides to do in evaluating whether there's a sufficient relation or public interest? Are they really well informed to give consistent and dependable assessments of all that? Long question, but I think you're following.
I think I follow you. And Judge Sabatino, to be fair, I planned to address this question as I went to the lawfully obtained prong, but let me just move there right now, because let's think about the Florida Star. You're going to hear me talking a lot about this case because it's a very strong case for us. In the Florida Star, it was a clerk in the police department who left the report on in the press room. So there are certainly more clerks in municipal police departments or employees in municipal police departments in Florida than there are clerks here. There's been a lot of talk that this case is different because this was obtained through Oprah rather than in a public courtroom or something like that. And I agree it's different. And I think it counsels in Mr. Kratovil's favor for the following reason. Clerks may be poorly trained. Clerks might not face liability, but they can. We have other statutes out there that require training, auditing, and impose liability for negligent disclosure. So I'm thinking particularly about the expungement statute. Daniel's Law has none of those elements. So they're not, this gets exactly to what Florida Star was talking about, which is if the government isn't making an effort to safeguard this information in the first place, it can hardly be said that they've taken the least onerous path, the most narrowly
Mr.
tailored.
Kratovil contends that the clerk was negligent in releasing the document to him.
That is an open question, Justice Patterson. Let me
I'm
explain
not asking
why.
you for fact finding. Is it his contention that she was negligent?
It is his contention that if Director Caputo had availed himself of the opt-in to Daniel's Law at the time that Mr. Kratovil made the request, then yes, the clerk was negligent. But that key fact is not part of the record in this case. And so we don't know that the clerk erred
But we
at
do
all.
know there was an exchange, there was a process that went on between Mr. Kratovil and the clerk. Am I correct that the first version of this that was produced redacted the information that we are here talking about?
That is correct.
And that your client made an argument that the clerk was relying on precedent that was overturned
That is also correct.
from this court.
Correct.
And was that true?
I don't think that's the best reading of Brennan. I think that's fair to say that if Mr. Kratovil were an attorney and we were critiquing the legal advice that he gave, it was not the correct legal advice. That doesn't mean that the clerk erred. And it certainly, as we get to the question about lawfully obtained, does not mean that Mr. Kratovil either violated the law, because people can make their arguments on why they are entitled to things under Oprah all the time. And if the clerk listens, that's not the proponent's fault that they've.
Well, I think that the Oprah law would suggest there should be a dialogue. But it does reflect on one of your three suggestions on how this problem can be effectively resolved, and that is the training of clerks. When the redaction would have eliminated this issue, and then your client came back with a legal argument as to the significance of one of our cases, Oprah cases.
Right, but the onus then is on the clerk to go to their independent counsel that they have, or to go to the Government Records Council help page. There's a million resources for the clerk to use. The clerk chose not to and provided the information to Mr. Kratovil, which gets me to an important.
And none of the discussion was about Daniel's Law, correct? The back
Never
and
came up.
forth was not that Mr. Kratovil was alleged to have said something legally incorrect about Daniel's Law, and then the clerk, negligently or not negligently accepted it. This was a totally separate thing that had absolutely nothing to do with Daniel's Law.
That is absolutely correct. And so let me put another kind of framing gloss on this, which is there's the entire Daily Mail line of cases, which talks about when journalists have obtained information that is true and they've done so lawfully, whether the government may prohibit or punish the lawful publication of it. There's a subset of those cases that deals with when it is the government itself that provides the information. And the courts have been even more absolute in those cases to say, when the government itself provides the information, it's really difficult. Thus far, they haven't found an instance where they can, where for the government to then punish you for publishing that which they already provided. They cannot provide it. And incidentally, that's a part of Daniel's Law that is not challenged here. Whether or not the government may withhold certain records, they can under Daniel's Law. And it gets to the question of the facial versus as applied challenge. And so There's some talk in the briefs about the Atlas data privacy cases, which are the facial challenges that were before the district court. And when the court found in Atlas that home addresses are not facially matters of public concern, that doesn't mean that they're never matters of public concern. It means they're not always matters of public concern. And Judge Bartle, in fact, invited as applied challenges. That's exactly what we have here. An instance where someone says, I've got a reason I need to publish this. So if I can move to the question of, is this a common sense solution that works for everyone? I note in my supplemental brief that after the city prevailed at the appellate division, the city put forth a press release where they impugned the reporting of Mr. Kratovil. They said, listen, Director Caputo, sure, he has a place in Cape May, but he really spends his time in Middlesex County. He has a pied-à-terre in one place, and he spends his weekdays here, and he shows up for all the meetings, despite what Mr. Kratovil had intended to report. And it's just not true, and it's because Mr. Kratovil's disgruntled and he has a vendetta against us. More or less, that's what the press release said. So a good journalist can respond to that by doing more reporting, by saying, okay, well, you say you're in Middlesex County every weekday. I'm going to talk to your neighbors. I'm going to talk to your neighbors in Cape May. I'm going to talk to your neighbors in Middlesex. I'm going to figure out whether that's true or not. But Mr. Kratovil can't do that. He's been essentially ordered to have this fight with a hand tied behind his back, but the city is punching away. And he shouldn't have to wait to respond till they've punched. He can do that in the first instance to put facts into his story that add to its veracity.
I'm having trouble understanding. I read this argument in your briefs that he can't move forward with this investigative journalism, can't speak to anyone. I'm having trouble understanding why that's the case.
Let me take a stab at it then, Justice Pierre-Louis. To be clear, he can speak to anyone he wants. It's reporting on it. So he can do the investigation. The question is whether he can then include those facts. So
facts that Caputo lives in Cape May.
That I
he
spoke to
someone who lives on his street, and that person indicated that he is there 5 days a week throughout the year.
Let me give you an example. There was reporting since the inception of this case about a United States Supreme Court justice who flew particular flags at his New Jersey beach house. And in the reporting on that case, they interviewed neighbors. How often was it up? When did it go up? Right? This was clearly an issue of public concern. And part of that is reporting neighbors. And you can name the neighbors, and you can name how close they live to the particular flag in question. And so too here, it's one thing to say one of his neighbors. It's another thing to say the person who lives next door to him. And now let's say that the person who lives next door to him has a unique name. I don't think we want to have a rule that says you can always report on protected people under Daniel's law's neighbors' addresses, just not their addresses. That's a weird rule. I think it's better for everyone to have a rule that is cabined to when it's an issue of public concern, and we decide it relates to that because the test is relational, then courts don't get involved in deciding which fact may and may not be reported upon.
But there's nothing to stop that report in the way that you've described to be issued. That article can go out exactly how you described, just without the address.
I'm not sure that's true. Again, if the question is, can someone who's up to no good derive the protected person's home address? If you're providing the name, the full name of the next door neighbor, and you're allowed to say it's their next door neighbor, I think you've kind of given away the farm on the efficacy of Daniel's law at that point. And again,
you're suggesting that would be a violation of Daniel's law in and of itself.
I'm suggesting it would be unclear to Mr. Kratovil, and it would prevent him, who's kind of trying to go about this in the most responsible way possible, from reporting from the most fulsome reporting possible, because he would fear that he would be subjecting himself to liability under Daniel's law. What he knows right now is he can write an article that says Director Caputo lives in Cape May. Additional facts: he lives in a 12-bedroom apartment or whatever, or it's
because the statute specifically says that it's not unlawful only to disclose, but also to disclose or redisclose on the internet or otherwise make available. So under the statute, you're arguing that this could be or otherwise make available.
Yes, and to be fair, I'm certainly not conceding that point. I'm not suggesting that I wouldn't give a vigorous defense to Mr. Kratovil if he opted to publish facts that otherwise made available Director Caputo's home address that he had not. But I don't think he can do so without any fear that he might be subject to repercussion.
There's really no question here that the issue is not about interviewing neighbors. The issue is about disclosure of the actual address, which everyone concedes is a violation of Daniel's law.
Let me give an example, Justice Patterson. And I know nothing about where anyone lives, but so on my block, if I said, Mr. Shalom lives in the smallest house on the block, it's the most ramshackle one, it's the only one, whatever. If I described it in ways that made it the only one, you're telling people where I live.
That's
without
not the issue
giving.
before. The issue before us, and this goes to the article that he would have written. The issue before us is the disclosure of the address.
So let me just step back.
It's not about whether descriptives and other factors and neighbors' names would have led someone through.
To be clear, that is a secondary and supplemental argument. If you reject that, if you think, well, he certainly can describe the house in vivid detail, he can talk about the neighbors with whom he met, that's fine. We still have the fundamental problem, which is that the lower courts and the city and the attorney general are failing to use the relational test that is mandated by the Florida Star.
So tell us the principle, the way you would like to see the court, explain the relational test of Florida Star as applied to Daniel's law that would, as you suggested, somehow leave out the case where a trial judge who is in the middle of an organized crime trial has their address disclosed.
I think what the court could say is the appropriate test is relational. We are going to look at the issue in general rather than the fact, the specific fact, because that is direct language from Florida Star. And then say, but the question is, what does it mean to have a relationship? What nexus is required? And we hold that the relationship must be at least as close as in the Florida Star. In this case, the distance one lives between one's home and one's work, their home address is a necessary component of that general issue and therefore has a much tighter nexus than that which was required in the Florida Star. But when the nexus is more remote than in the Florida Star, it may not. We'll have to evaluate that case separately.
Where do you get that from Florida Star? Because I saw Florida Star more as the Supreme Court looking at the news article as a whole,
right,
saying that it involves a matter of public significance because, quote, the article generally, as opposed to the specific identity contained within it, involved a matter of paramount public import, the commission and investigation of a violent crime. And then just saying, and it's up to the editors to decide what can or cannot go into that article. Where did they specifically discuss the victim's identity and how close of a nexus that is or is not to the commission and investigation of a violent crime?
So to be clear, it's exactly the passage that you just read, Justice Wainer, is the one upon which I rely. They don't discuss that, but what we know is they found the nexus close enough there. They said, we're going to look at.
Or maybe they didn't even require an nexus. To me, when I read it, it made it seem more like it's the level of generality at which you are deciding if this is a matter of public concern. So they decided we are not going to ask whether this victim's name, even though the statute only prohibits the release of a victim's name, we are not going to ask, is this specific victim's name a matter of public concern? Instead, we're going to say, this reporter lawfully obtained the victim's name from the police department and then published an article about a matter of public concern. And we are finding, because the article itself was a matter of public concern, that the reporter cannot be lawfully punished consistent with the First Amendment.
Justice Wainer, that's exactly how I read the Florida Star. My position that I was just articulating is that if you want to put guardrails on, if you want to place the
That
limitations
this
that
court could narrow Florida Star is what you're saying?
no, that under principles of federalism, this court can go down to, but not below the limit set by the Florida Star. Yes, I actually read it exactly the way you just described. But if the court had the concerns that Justice Patterson articulated, you can say, well, all we know from the US Supreme Court is it can't be a smaller nexus than that. And if it is, then it's got to be okay.
Would
But if
you, I'm sorry, I'm finished.
I'm finished, Judge.
Would you agree that if the relevance or relation is fairly debatable, that a prudent records custodian should not release the information and let a court make that call? Because courts in civil discovery, for example, are constantly deciding, is this request sufficiently related to the issues in the case? Wouldn't the prudent way, even though it might result in some interim restraint on publication, be to let a judge decide that close call rather than having 500 or more records custodians try to make a quasi-legal judgment?
Judge Sabatino, on the one hand, I agree with you 100% that, of course, we would want judges rather than other people making those decisions. But I actually think you're reading too much into it, which is no one has suggested that the records custodian couldn't. The question of public interest doesn't really come into the initial disclosure. The question is, once it's been disclosed, can the government threaten civil and criminal prosecution for repeating what you got? And so, but we did come to court, right? One thing that Mr. Kratovil could have done is he could have published and then challenged. But we came to court to say, hey, we have this emergency. We think there's a prior restraint on speech in violation of the First Amendment. And here we are 20 months later, hopefully getting closer to a resolution of that
I wanted
matter.
to make sure I understand. So you're not arguing that a records custodian might be required to release information whose release is prohibited under Daniel's law because that information is related to a matter of public significance or some reporter alleges that it is. You're just saying if the record custodian releases it and the reporter puts it in an article or wants to put in an article that is itself the article about a matter of public importance, the person cannot be constitutionally punished for doing that.
That is exactly right. So
does it mean that the subsection A, in the civil, not the 2C person, subsection A proviso or condition that a person not only ceased further disclosure, but then must in some way, not describe, remove the protected information from the other internet or where otherwise made available? Are you hinting at or suggesting that this removal obligation is unconstitutional as applied? I'm having a little trouble myself conceiving if the reporter then disseminated it, what at that point could be done, because it's out there.
Yeah, I mean, I think that probably refers to taking down the website. I mean, there was a recently reported case in Mississippi where a newspaper was ordered to take down an editorial.
How efficacious is that?
So efficacy aside, and I think it's a very important question. I think the efficacy questions are kind of run through this conversation, but in this as-applied challenge, it's not the.
We're not there yet because there hasn't been an accusation made that there was conduct by your client that where he was obligated to do something affirmative to take back what he already had.
That's right.
disseminated.
That's right.
But it seems like that would be something that would arise, frequently when these requests are made or when there's some partial disclosure made.
And so I want to just pick up on a word you just used, which is arise frequently, a phrase that you just used, arise frequently. I think it's important to note that Daniel's law has been around since 2000, in its current iteration since 2020, and 2023 is the current iteration. This is the first time this has come up. So it's not that this is going to open the floodgates to the dissemination of information, because most often it's going to get stopped at the initial disclosure stage. And so the idea that
Great faith in that. Why wouldn't someone be motivated to simply ask do a mass Oprah request of municipalities for the home addresses of police officers, chief of police, any judges who happen to live in the town, and see if any mistakes might be made?
I have no answer to why they wouldn't be motivated to. What I have an answer to is that it hasn't happened yet, that we've had 5 years of experience and it hasn't happened yet.
Well, and it wouldn't violate Daniel's law unless each individual person had opted in, correct?
Right?
So there's no automatic provision of Daniel's law. Each individual person has to fill out the required information, request that their information not be provided in response to a request, et cetera.
That's exactly right.
And the disseminator must be provided notice under Daniel's law to
Correct.
initiate any potential violations, if not taken down or whatever.
Also true,
happens to be.
what we've been
So
calling.
there's a lot that has to happen to trigger Daniel's law provisions.
So if there were Oprah requests en masse to all 500 and some municipalities, unless people had opted into Daniel's law, presumably those records custodians would be required to produce all that information. And
Yes.
what is so far a unique situation for Mr. Kratovil could become a very substantial situation with respect to Daniel's law.
That's plausible, Justice Patterson. I can't doubt that it's plausible. It's also not the situation we have, and we have an as-applied challenge where one person in the last 5 years has gotten this information from the government, happens to be a journalist, happens to want to write about a matter of public
Why would
concern.
that be an issue under Daniel's law? If people had not if the individual members of the government who could be protected by Daniel's law had never opted in
Then it's no issue.
requested protection, then whoever wants can get their information under Oprah and publish it however they want to, because the person is not protected by Daniel's law unless they specifically request protection, correct?
That's correct. There might be other provisions probably of Title II-C that would prevent the just kind of mass dissemination of home addresses under doxing provisions, but that is not what we're talking about here, since everyone agrees that there's at least this adjacent matter of public concern. I'm going to quickly move to the other elements. They should be really much quicker. No one debates that this matter is true, that he received the actual home address of Director Caputo. It's also not really a matter of debate that Director Caputo's home address was widely available in July of 2023 when we appeared before the Middlesex County Superior Court, and that it was lawfully obtained. We've had some discussion about whether Mr. Kratovil gave what is arguably bad legal advice. That doesn't make it not lawfully obtained. The cases on this are clear, whether we're talking about both Bartnicki and the Pentagon Papers case, where there was actual illegality, just not illegality by the journalists, or whether we're talking about cases like the Florida Star, where there was erroneous disclosure. That doesn't, and the reporter in the Florida Star broke the rules, knew she wasn't supposed to write it down, and nonetheless wrote it down. That doesn't change the Daily Mail analysis. It is still lawfully obtained. So that then gets us to the narrow tailoring inquiry. And again, just to reiterate what I've already said, there's no doubt in this case, we have not challenged that this is a government interest of the highest order. The question is about narrow tailoring. There's some suggestion by the city that we should defer to the legislative choices, but the essence of a narrow tailoring inquiry, as the US Supreme Court teaches in Ashcroft, is that we don't defer to legislative choices, and we actually ask whether there are alternatives that could roughly equally satisfy the government interest. And so I've talked about the first one, and the Florida Star is very clear about this, that when the government affirmatively gives you the information, courts must make the assumption that they had a better way to prevent publication other than subsequent criminalization or civil penalty. They didn't. And I talked about auditing, I talked about training, and I talked about criminal penalties, none of which are
Let
found.
me pause you on training, because training would be, it would essentially say, it would be training that would say that if this particular individual had invoked Daniel's law and gone through the process, you should not produce that in response to an Oprah request?
Correct. It would say that when you get an Oprah request that includes in it either the answer is either has a home address or an unpublished phone number, you should check that record against the Daniel's Law database to decide, to figure out whether this person has opted in. And if they have, you don't turn it over. And if they have not, you do turn it over.
I thought Daniel's law actually redacts the information in the government databases to begin with, so maybe it wouldn't even be the custodians to hand over?
I don't think that's true in this case, Justice Weiner, after, because it would be hard for that information, the home address to be redacted in a voting record where it's so central to, right? Are you in the right precinct and district? So I don't know, you might be right, but even assuming that it's not redacted in the government record itself, which might be the case, the training is pretty straightforward. It's not hard. And like I said, we know with expungement, we tell clerks, if you disclose this erroneously, you are looking at a fine. This is what they were talking about in GDV Kenny. And no such provision is found in Daniel's law. And there's also auditing. Are we checking? And so, Justice Wayner-Apter, if you're correct that it should be redacted in the original material, then that's a clear place where the government could be auditing.
Is that if all those things were implemented? Your position, though, is if the releaser makes a mistake, the court must honor the journalist's entitlement to publish something they lawfully obtained.
That's correct.
With no balancing done at all. It's happened, got out. We're stuck with that.
I think there's always a balancing, Judge Sabatino. I think
what are you balancing, though? You said that these are the measures that the government has at its disposal. We took them all. Unfortunately, something got out that shouldn't. So what's the remedy available to deal with it to protect the privacy of those that have registered?
So maybe I misspoke when I said there's always a balancing. Let me say there might be a balancing. In Ostergren, the Fourth Circuit case that I cited to, this is about the widespread dissemination of Social Security numbers.
Can you provide the citation? Sorry. Or just the full case name, Ostergren?
Gren, Ostergren, and I'll provide the citation during rebuttal. In Ostergren, the question, Virginia had Social Security numbers on all sorts of property records. They had them in the basement of their town records rooms, and they put them online in unredacted form, just a mass list of Social Security numbers. And so a privacy advocate said, just to show Virginia how silly they're being with privacy, I'm going to publish exactly what they've given us on the internet. And the court in Ostergren said, listen, there might be a different test if the person is going into the basement rooms to find these Social Security numbers. But here, where the government is making them readily available on the internet, then they can't constitutionally prohibit her from doing so. And so too here, we might have a different case if Mr. Kratovil had been scouring the dark web to find Director Caputo's address. It was the #1 hit on Google. It wasn't hard to find, and he got it from an Oprah request.
So you're saying that any balancing would refer to what the journalist had done or needed to do in order to get the information?
I would look at it.
The circumstances that someone on the other end of it might be experiencing. For example, somebody who's under an active threat, requiring security and so forth.
So I would look at it, the balance in a slightly different way, Justice Patterson, which is I would look at the steps that the government had taken to safeguard the information. And so if we learned that they had done many things to safeguard it, but someone found the archived edition from 1984 of a home, that might be a different case. But again, since we're in an as-applied place, we don't have to ask that. We just have to know that all Mr. Kratovil had to do was send an Oprah request or go on to Google, right? In many ways, the Oprah request just confirmed that which was readily available to anyone who had a search engine.
None of these Supreme Court cases that you are discussing in the Daily Mail line of cases or others about when someone obtains information from the government, lawfully obtains information and then publishes it, none of them considered the privacy of the home, which the Supreme Court has acknowledged is granted, quote, special consideration in our Constitution, laws, and traditions. How is that relevant to this case?
I don't think I mean, it's true. The privacy of the home matters, but so does the fact that someone is a victim of a crime. I mean, and particularly that crime, and which is to say sexual assault. And at the time, just to be clear, the perpetrator in the Florida Star was at large when the Florida Star published that article. Right? So there were real safety concerns for BJF. And the court didn't find that any of those trumped the First Amendment principle. So, Justice Wayner-Apter, I can't deny that the home is entitled to special solicitude. I just don't think it changes the First Amendment analysis.
We did recognize that in State versus Ramirez, I believe, right, with the defense wanting to get access to the victim's home address. And there were guardrails placed on it because of those special considerations, right?
Without a doubt, special considerations. And in Ramirez, the court also found that there were ways that the defense could access that. And so we're not suggesting that willy-nilly people lose an expectation of privacy in their home address. Instead, we're suggesting that under these peculiar facts, Mr. Kratovil has a right to publish. If I can get to the second narrow tailoring failure, which is the exception that exists in the federal Daniels law. So the federal Daniels law, the very law which members of the federal judiciary lobbied for their own protection, makes an exception for exactly this situation. For instances where the information was provided and is reported in a news article or an editorial on a matter of public significance. I think they did so because they thought it was constitutionally compelled, but whether they did or didn't, the federal Congress thought that that was a sufficient way to protect federal judges. And there isn't evidence that it is insufficient here in New Jersey. And the final piece is the criminal versus civil. I'll just say a very quick word on this. The Attorney General suggests that the criminal piece of Daniels law is not before this court. That is plainly wrong. It is before this court, first of all, because we pled it and we're at the stage where we're relying on my pleadings. But beyond that, the letter that Mr. Kratovil got that told him that he couldn't do this anymore, that he had to not talk about the home address anymore, first of all, it cited both the civil and the criminal provisions. And second of all, it copied the first assistant county prosecutor in Middlesex County. It is quite a stretch to think that you would copy the prosecutor on a civil-only notice. And if that isn't enough, just if we accept the Attorney General's construction on when the criminal law, which requires a reckless disregard for the safety of the covered person, is implicated, what they say is it can't be enough to just know that a covered person is covered.
The appellate division noted that what that letter was, I'm leaving aside the copying of the prosecutor's office, is Daniels law notice. It's what was statutorily required. Simply kindly accept this letter as written notice as required by the above referenced statutes. There's no threat of prosecution. There's no threat of a civil penalty in that letter.
Well, except that it references a statute that has a threat of civil penalty, and it references a statute that has a threat of criminal penalty.
Right, but it's a reference to a statute. It's not. We are going to send somebody out and arrest you.
But if someone receives a letter that says, "Do not engage in terroristic threats," and includes a citation both to the terroristic threat statute and the sentencing statute, one can assume that implicit in that is that if you do, you are subjecting yourself to criminal prosecution and between 3 and 5 years in state prison.
And here also there's a line that says, I trust you will be guided accordingly.
Right.
Thus implying that there is some force that must guide you.
And Justice Patterson, you left out from the hypothetical that they were copied, but Mr. Kratovil can't, right? Mr. Kratovil got this letter with copy to them.
I understand, but with the exception of that aspect to it, it seems to be what is a letter that tracks the statute.
It absolutely tracks the statute.
Interpretation by the city of what notice of under the statute should look like.
I want to be clear that when I refer to this as a cease and desist letter, I'm not suggesting anything nefarious. It is exactly what is required by Daniels law. But they invoked both the civil provisions of Daniels law and the criminal provisions. My last point, just to finish up here, the state says merely knowing that a person is a covered person cannot evince reckless disregard, and that might be true. But Mr. Kratovil knows more, because the city has introduced in this litigation evidence that they purport suggests a unique threat that Director Caputo faces. It hasn't been subject to adversarial testing. I'm not accepting it, but it certainly exposes Mr. Kratovil to the potential of criminal prosecution, and that's enough to invoke it in the narrow tailoring inquiry in the way the Third Circuit did in Schrader.
So if the letter had omitted the carbon copy to the prosecutor and omitted any reference to the criminal side of it, you're not contending that if the requester lawfully obtains it, that they're criminally immunized at all. It's just that the problem is the coercive nature of putting that in the letter. But your client, if their client hypothetically did recklessly divulge, et cetera, the fact that it wasn't in this letter would not give them any kind of immunity or protection, right?
I assume that's right. I'd have to look a little more closely at the criminal statute on that question, which is to say, is the warning a prerequisite for criminal prosecution? But the limited point about which I'm speaking on the criminal side is when we look at narrow tailoring, as the Third Circuit did in Schrader, the question is, could they achieve the same stuff with just the civil sanctions, or do they also need the criminal sanctions? And if they don't need the criminal sanctions, then it's not narrowly tailored.
Thank you.
The AG distinguishes Florida Star on the basis there's no post hoc liability being imposed here. So there's none of the unfairness raised by a reporter receiving information from the government and then publishing it only to be thereafter faced with a tort suit or criminal liability. How do you respond to that?
Right. Instead, what the reporter is faced with is a prior restraint. This is right in the First Amendment hierarchy. This is the thing about which we worry most, telling reporters what they can't do before they've even done it. And that's what we have here. And so it is different than Florida Star. And Justice Patterson, you started my colloquy about the Florida Star by saying the facts are different. It is, but it operates as precedent. And we have to be guided by that. First, in how it defines the issue of public concern, and also in how it looks at narrow tailoring.
And on that issue, you're asking us to stop at Florida Star and not go to Snyder?
You don't,
for the issue of public concern, because we're not, you're suggesting that we're not looking at the specifics of the content, the context. You're asking us to stop at Florida Star?
no, I'm not suggesting that you can't look at Snyder. I think Snyder is very helpful to us, right? In Snyder, the context was a funeral, something that is deeply private and personal. And they said, notwithstanding that, the overall thrust of the message of the Westboro Baptist Church, the overall thrust of their message was on issues of public concern. Here, if you look at the context, it's a news article, right? The very pinnacle of the hierarchy of First Amendment rights. And so I think Snyder is extremely helpful for us, but I think the case can be resolved just on the Florida Star.
Do you, I'm sorry, go ahead. Do you agree with the trial judge's characterization of the state interest of the highest order here? Was homicidal attacks or threats upon judges, law enforcement officers, or prosecutors, or members of their family is a state interest of the highest order. And he went on to say it would be hard to discern a state interest more compelling. You are not contesting that.
Correct. Justice Manoraptor, did you have a question?
In terms of Snyder, the court looked at the overall thrust and dominant themes of the sign and to then ask whether it could be fairly considered as relating to any matter of political, social, or other concern. So it didn't specifically say, well, this sign, because it was not related to a matter of public concern, there can be intentional infliction of emotional distress damages based on this sign, but this sign, because it is a matter of public concern, there can't be damages related to that sign.
That's exactly right. In fact, the court looked at all the signs. It identified two signs that they thought were particularly personal rather than public, but said that the overall thrust of the signs in general was sufficient. And that's exactly that is consistent with the analysis in the Florida Star, that we're looking not fact by fact, but at the broader issue. Unless there are any questions, I'd ask the court to reverse, and I'll be back for
Thank you for having me back on rebuttal. Mr. Corrado.
In enacting Daniel's law and in preventing the disclosure of home addresses.
Yeah, I agree that the legislature has the right to make that decision, but that doesn't answer the question of whether a newspaper or a court can say that this sort of information can be in a news story or not in a news story. I'm asking I'm sorry.
It's your argument. Is it still your argument that you don't believe that this is an interest of the highest order?
I defer to Mr. Shalom on that. If he's conceded that or is arguing that it is not. I don't have a problem with that. My client's concern here is that this court make it clear that courts cannot say what should be or not should not be in a story.
Well,
they can't make that determination. They can't make that kind of determination without intruding contrary to the Tornillo line of cases, into the First Amendment protections that the press enjoys.
Well, respecting constitutional values, though, there are still limited areas, right, where courts can constitutionally second guess editorial decisions if they're made, for example, in reckless disregard of the truth and that sort of thing.
Of course,
So
that's
New York
true.
Times versus Sullivan, I mean, the editorial room is not completely sacrosanct and
I certainly don't disagree with that.
except,
I've spent many-
able to autonomously decide all these things. There's a level of tolerance that our system has here with free speech and editorial judgment versus countervailing public value. So it's not like there is an inability of the legislature or the court to intrude in certain instances on those decisions, right?
I couldn't agree with that more. But there's a big difference in my mind between a court deciding whether a newspaper has published with reckless disregard of the truth and a court saying you can put this information in the story, but you can't put this information in the story because it's not necessary to tell the story. Those are two entirely different things, Judge Sabatino, in my
What
opinion.
about troop locations at time of war, for example?
I'm sorry.
What about troop locations during wartime?
Here
That's
versus Minnesota,
Right.
of course not. But that goes to the question of whether the case or the action of the state rises to a level that satisfies the Daily Mail test. Or
But if a court were to rule in a case like that, a hypothetical case like that, and simply say that in order to explain to the journalists that there is a story that can be told here, that the journalist can report on the comments of the soldiers or the experience of the soldiers or whatever it is without revealing the location, that is very similar to what was done here. I mean, it's trying to state the standard in a way that allows the journalist some guidance as to what can be reported.
well, but that's not what happened in this case. What happened in this case is that Mr. Kratovil has essentially been told that he will be punished in some way. And I heard the dialogue between you and Mr. Shalom about what was in the letters and back and forth, but I happen to think that correspondence was a kind of a veiled threat. But in any event, Mr. Kratovil was essentially told here that if he published, he would be punished. That's different than a court engaging in saying, if you do this, this is not the kind of interest that couldn't be a prior restraint. It couldn't be restrained.
But I don't think the court that went that far. I understand that's an interpretation, but that's not what the appellate division said, and it's not what the trial court said.
Well, the trial court said specifically that there's no logical reason for this information to be in this story. That it doesn't add anything to the story, and it's just not a court's job to make that kind of a determination. And my concern is that if this decision is allowed to stand the way that it was made by New Brunswick and affirmed by the lower courts, I think that it creates kind of a slippery slope or raises real concerns that are going to chill journalism. And I urge this court, as part of its opinion in this case, to make clear that that kind of intrusion of a court into the editorial process cannot be tolerated, because it does violate the constitutional protections that the First Amendment gives to the press.
And you mentioned the First Amendment. I just want to clarify something. I didn't ask Mr. Shalom. You're additionally arguing that under Article 1, Paragraph 6 under the New Jersey Constitution. I thought you were.
Well,
maybe I'm wrong.
No, you're not wrong at all. As a matter of fact, I think our principal argument is under the New Jersey Constitution.
And what is unique or special here under, we have factors, state versus Hunt, and all that, at times when New Jersey can add to the protections that are available. Why in this case should this court determine that there's even greater, no matter what the national landscape is under the First Amendment, that there's something unique about New Jersey's protection of reporters that warrants a different outcome?
I don't think that I can articulate as we stand here today a reason why there should be any additional protection as there was in, say, the shopping center cases or the condominium cases. The Twin Rivers case that I participated in. But certainly, as Mr. Shalom made clear, the federal Constitution is a floor, not a ceiling. And New Jersey, this court has the ability to say that New Jersey reporters are entitled to more protection against in-court intrusion into the editorial process. I'm not so sure, without going further back into the facts and the record, that I can articulate a specific reason why.
And I didn't see that in any of the presentations.
I don't
either
think
by
that
you or Mr. Shalom. I thought what we were being asked to do is apply the Daily Mail line of cases. There's also an invocation of our constitution, our state constitutional provision.
I believe that is
I
correct.
just want to understand that is the argument.
I believe that is correct. And the argument was made that the GD versus Kenny case essentially adopts that line of cases into New Jersey law as part of the New Jersey constitutional.
Any other questions?
I'd like to make one other point, but it's not strictly media related. I think that the appellate division in the lower court got the burden of proof wrong in this case, backwards. This is a constitutional challenge to a restraint on speech, and therefore it's not the restraint is not presumptively valid. As a matter of fact, the burden is on the state or the city in a case like this to prove or to demonstrate that the proponent that as the proponent of the restraints, they have to demonstrate the propriety of the restraint.
But this is a facial challenge against a statute that the legislature passed and the governor signed. So there's a presumption of constitutionality that applies.
Not when, but the way in, this is an as applied constitutional challenge to the way in which the city is imposing Daniel's law on Mr. Kratovil, or attempting to, or proposing to impose the law on Mr. Kratovil. And therefore, I believe that the burden is on the city to justify the restraint. And the appellate division and the lower court essentially said that Mr. Kratovil has the burden of showing that the inclusion of the home address is necessary for the story.
So whose burden is it to prove that, as applied to a particular setting, as we have here, a statute is unconstitutional?
It's the burden of the city in this case. The city's burden in this case is to prove that exclusion of the store of the home address is necessary to protect the interest that it advances.
Do you have any authority on that?
I do not, other than the general principle that when First Amendment, excuse me, that when restraints on speech are challenged as unconstitutional, the presumption is flipped.
Does the fact that we have here a statute change that? This is an unusual First Amendment case.
What we have here is a case where the statute is proposed to be applied. This is as we've made, I hope we've made clear, this is not a facial challenge to Daniel's law.
No, I understand. No, I understand it's an as-applied challenge. But whose burden is it to prove the unconstitutionality of a statute as applied?
If the constitutional challenge is one that involves a restraint on speech, it's the burden of the proponent of the restraint.
Thank you. Any other questions?
Thank you very much. I echo Mr. Shalom's request that the court reverse.
Thank you.
Good afternoon. Please, the floor. Just going to make an opening statement, and then we can discuss the cases as you've been discussing all morning. Okay.
You can keep your voice up as best you can.
Sorry.
If you could keep your voice up as best you can.
Of course. Thank you. This case involves a reporter of an online blog, and he's seeking to publish the private home address of former Director Caputo in an article criticizing Director Caputo's job performance and alleging that the distance between his permanent residence and the city of New Brunswick was instrumental in Caputo having a no-show job. The record's clear that Caputo's position in the city of New Brunswick did not contain a residency requirement, and that Caputo lived in Middlesex County during the week and as needed on weekends. Plaintiff sought information concerning Caputo's private home address on 2 occasions in March of 2023 from the city, once in April of 2023, and then from the city council in April of 2023. After the first time that he sought information, after being told that the address was subject to Daniel's law, he sought voter registration records. And after back and forth with the clerk, who at first redacted for personal information, he received Caputo's home address. This information was publicly announced on April 17, 2023 at the council meeting, and a copy of the voter registration forms were provided to council members. No action was taken against plaintiff at this time. On May 15, 2023, he received a letter under the requirements of Daniel's law requiring notification, advising that Caputo was a covered person and requesting that plaintiff not redisclose his private personal information. This opt-in provision, as I said, is a requirement of Daniel's law and permits individuals to control their own personal information. Plaintiff published this letter on Facebook and Twitter. And he indicated on Facebook and Twitter, look at the letter I've just received. And this is because Caputo lives 2 hours away from his job. No action again was taken. Instead, 2 months later, plaintiff filed an order to show cause, which was denied by the trial court. And as you know, that decision was upheld by the appellate division. This case turns on the tension between Article 1, Section 1, privacy rights, and Article 1, Section 6, the freedom of the press. This order to show cause is based upon the New Jersey Constitution. The question before the court is the constitutionality of Daniel's law, which was enacted to protect and limit disclosure of private home addresses of those covered persons, being judges, prosecutors, law enforcement, and DCP&P investigators. In addition to private home addresses, Daniel's law covers unpublished home telephone numbers, and as defined, it's either a cell phone or a landline. The law specifically prohibits the disclosure, redisclosure, publication, or republication of a covered person's home address, but only after notification is provided. In other words, there can be no issue with respect to Daniel's law until that notification is provided. The purpose, obviously, is to protect the privacy of the individuals and their families so that they could continue to do the job free from harm. Now, it was gratifying to hear that the plaintiff has conceded that the protection of those covered persons is a state interest of the highest order, because there is no question that the incidence against these covered individuals has increased over the past 10 years, and it takes the form of doxing and harassment and sometimes even death. The rising violence and the divisiveness has been multiplied by the internet, or the ready access afforded by the internet. And this law, of course, culminated after the death of Judge Salas' son, which is why this law is named Daniel's Law. This Daniel's Law has a strong presumption of constitutionality. The federal cases cited by the plaintiff are cases which specifically reject the contention that at all times, truthful information can never be punished consistent with the First Amendment, and that there is no zone of personal privacy that may be protected. Each of the cases cited by the plaintiff are limited to their specific facts and holdings. In this case, the record shows that Mr. Kratovil, through his counsel, had been notified not only by counsel for the defendant, but also the underlying courts, that he may publish his article concerning any criticism of Caputo that he may have, along with the fact that he lives in Cape May. The sole question is whether the publication of the street number and the street address, which add nothing to the article that plaintiff wants to write, should be permitted to be disclosed. Our consistent position is that given the compelling interest of protecting these covered persons and our public servants, and the privacy interests and the safety interests necessary to permit those public servants to do their job and to guard their information and to protect their families from this onslaught of violence, that the street number and the street name are not a matter of public importance, and therefore it does not add anything to the free and robust debate on the public issues that plaintiff is espousing. His request to bootstrap non-relevant personal information should not be tolerated by this court. I welcome your questions.
You're in your brief, page 12, you argue that Mr. Kratovil's reliance on Florida Star fails to consider later case law, and then you go on to discuss Snyder. Is it your contention that Snyder dials back the holding of Florida Star in some respect? And if so, what's the basis for that argument?
So my contention is that, again, these are all as applied challenges, but Snyder restrict the private speech and it does not implicate the same constitutional conduct as limiting speech on matters of public interest. There's no threats to robust debate. I do believe that based upon the facts in Snyder, which obviously were different than Florida Star, the principles there are different. And they were different because the facts were different and based upon the law.
Well, which is the closer case to, these are as applied challenges, which is the closer case to this case of the two?
Well, Snyder did not touch on private concern, right? It was related to issue of public importance, and the public importance cannot be impacted with respect to private information. Florida Star talked about the publication of a victim, the name of the victim. The issue in Florida Star, I think, however, was that they do not hold that truthful publication or that there is no zone of personal privacy that the state may protect individuals from intrusion by the press. In those specific circumstances, with respect to I don't really know that it was as fully discussed as it is in this case with respect to the personal address. But there was a publication with respect to that particular victim. But they were very, very careful to say that we don't hold that truthful publication or that there is no zone of personal privacy that the
In
state may
Florida Star, there
protect.
was a statute that made
I'm
it
sorry.
unlawful to.
Could you
Sorry.
repeat yourself, Madam Justice?
In Florida Star, there was
Yes.
a statute that made it unlawful to print, publish, or broadcast in any instrument of mass communication the name of a victim of sexual offense. And the United States Supreme Court held that that statute could not constitutionally be applied to a newspaper that violated it by publishing the name of a victim of a sexual offense, because the newspaper had lawfully obtained the information. So I wasn't sure in your explanation just now why or how you think that's relevant or not relevant to this case.
So there's differences in that case versus ours. Ours is an opt-in where people can regulate who has dissemination with respect to personal information, number one. Number two.
Please keep your voice up and as best you
sorry.
can. It's just difficult to hear.
Number two, with respect to Florida Star, saying that the media cannot publish it without respect to concerns relative to a higher interest and public policy, then I do not think that it would be necessarily binding on this court as to our case.
I think the parts of Florida Star that your adversary is relying on are two. One is what is a matter of public concern. And in Florida Star, the Supreme Court, I think, pretty clearly says because the article itself is about a matter of public concern, crime, it doesn't matter if this particular victim's name is or is not necessary to that story or is not a matter of public concern. You look at the general article, which is about a matter of public concern, and that's it. And then I think your adversary is also relying on the narrow tailoring piece, where the Supreme Court seems to be pretty strict in how it's construing narrow tailoring with a lot of language like where the government itself provides information to the media, it is most appropriate to assume that the government had but failed to utilize far more limited means of guarding against dissemination than the extreme step of punishing truthful speech. So how do you distinguish Florida Star either in terms of whether it's a matter of public concern and the very broad way they looked at that, or the very strict way they looked at narrow tailoring to say, this was not narrowly tailored because of all of these reasons?
So the issue with respect, and I think really what you're getting at is with respect to the related to issue that Mr. Shalom and Bimici has indicated. It is in this instance, the address itself is not related, as indicated by the trial court and the appellate division, that it is not related to the nature of the public interest that wants to be discussed. That is, he lives 2 hours away from Cape May to New Brunswick. In the Florida Star case, the general article in talking about relating to the matters of public concern, they found that that victim's name could be published despite that statute. And I understand that they did that, but I do not believe that that is, if you will, binding in terms of how to look at our case because of the nature of A, the personal opt-in, B, the notification that had to occur, C, the issue with respect to whether or not that is germane or goes to the thrust of the story as to whether or not Caputo has a, quote, no-show job.
Who's in the best position to make that assessment?
So in this instance, I understand that there's question with respect to editorial privilege and with respect to, and Amici has argued that editors should have that privilege. I think it is a little different when it is a big conglomerate like the Amici represents versus individual bloggers on internets because that editorial privilege then resides with them. The question really is when you look at the content, form, and context.
I'm sorry, that last point, the editorial, you've talked about conglomerates and then bloggers, and then the editorial privilege resides with them. Who's them?
Okay, so obviously, if you have a conglomerate, you have newspaper reporters and you have levels of supervision with respect to editors. When you're an individual blogger, it is just you.
But in Florida Star, didn't the U.S. Supreme Court discuss precisely the opposite when it comes to narrow tailoring? They said, when a state attempts the extraordinary measure of punishing the truthful publication in the name of privacy, it must demonstrate its commitment to advancing this interest by applying the prohibition even-handedly to the small-time disseminator as well as the media giant. So Florida Star, the statute only prohibited a media giant.
Correct.
And the Supreme Court said it's not narrowly tailored because it needs to prohibit everyone. You now seem to be coming from the opposite perspective and say, the media giant should have editorial control, but an individual blogger should not.
No, what I was trying to explain that there is a difference with respect to the editorial perspective. And I was trying to explain that in response to Judge Sabatino's question, is that courts should be able to make that decision in terms of context, form, and content.
Why not accept the premise that the plaintiffs have made, that as long as we lawfully got it from a clerk or records a custodian, that we should be able to rely on that and not have to litigate it? What's your response to that?
But then the question is it narrowly tailored to serve an interest of the highest order? And as I said, I think we've agreed that there is an interest of the highest order with respect to the protection of covered persons and their personal addresses. Once that person opts in and advises or notifies the reporter. And so if there is a disagreement, which obviously there was in this instance, as to whether or not Mr. Kratovil could publish going from Cape May to New Brunswick without the use of the address, plaintiffs are the ones that filed the order to show cause.
Should they have to do that if it's been disclosed, even if it's negligently disclosed?
If it's negligently disclosed, I believe that's the standard with respect to the violation of the civil statute. It's a different level, obviously. with respect to
Not
criminal.
negligently disclosed by the plaintiff, but negligently disclosed by a clerk. They get it lawfully, but mistakenly by a clerk. Can they, at that point, say, well, now there's no longer any need for them to demonstrate anything or go to court because applying the narrowly tailored test, they've done what they're supposed to do, which they've gone to the government. The government gave it to them. I think that's their position.
So the interesting thing is you have NJSA 4718-3, which are exceptions to the redaction requirement. One of them is the home address and voter registration files, which is exactly what we're talking about here, right? But Daniel's law on top of that specified exception prohibits the posting or reposting, the publishing or republishing. That's why when I specifically talked about any action being taken, we didn't take any action until we sent that opt-in letter notifying of the fact that we would object to any person specifying the home address.
So I gather, though, your point is that even if it's negligently disclosed, if there's a higher public interest that's present, that's for a court to decide, and the requesting party should hold up until the court makes a decision.
The requesting party in this case can obviously have published that article many, many months ago. It is a question now as to whether or not, and I'm not in Mr. Kratovil's mind, whether or not he intends to still publish that article, and if he does, whether or not he still wants to publish it with Director Caputo's home address.
Sorry, can you say that one more time when you said that Mr. Kratovil could have published the article a long time ago? You mean consistently with Daniel's law?
Consistently with Daniel's law without utilizing the address. In other words,
oh, I'm sorry. Okay.
He's been told from the beginning that he's more than welcome to talk about the issue of public importance and how it goes with respect to 200 miles or whatever it is, and the difference between Cape May and New Brunswick. His issue of public importance is that Caputo was a no-show job and that Caputo was not performing his job because he was elsewhere.
How do you respond to Mr. Shalom's point that if he had interviewed neighbors and other folks in the vicinity of where Mr. Caputo lives, that he might have inadvertently revealed his exact address without specifically publishing it, which may still put him in jeopardy of violating Daniel's law?
So it's so interesting because the example that Mr. Shalom used was the flying of flags of a.
And we need to, I'm sorry to be a broken record, but.
Flying
it's
of
very hard for us
flags
to
of
hear.
a Supreme Court justice down the shore somewhere. And any of the articles that I've ever seen never spoke about the actual address, right, of that. And there was information in those articles where they went and spoke to neighbors. What did you think about him flying X flag? And that was reported. Under Daniel's law, unless those neighbors get a letter saying, please don't discuss my information. And then if Caputo knew that that information was being discussed and then sent a letter to Mr. Kratovil, then perhaps, because I understand
Perhaps what?
I understand the court's point where otherwise make available. So it's with respect to Daniel's law has to do with the protection. And I think that once that a reporter or anyone receives that letter, they're responsible with respect to protecting all of us, all of our covered persons.
So it's my understanding that Mr. Shalom's argument was a journalist would not be on notice of what they could write based on his argument that if he interviewed neighbors and the neighbor had a very distinctive name or distinctive look of their house, then it would easily be revealed where Caputo lives or whoever else an article is being written about. So what is your response to that? That if we were to hold that, if we were to hold as you're arguing, would journalists be on notice of the limits to which they could report with regard to possibly inadvertently revealing a covered person's address under the statute.
The threshold question in that case is whether or not the journalist received a notification from the individual who was affected. If the journalist went and spoke to neighbors and former Director Caputo knew nothing about that, there would be no possible way that he could actually send an opt-in letter saying, please do not publish my information.
Here he already has. So Mr. Kratovil received the letter.
Yes.
And then the city came out and said, this whole thing is nonsense and he's not a no-show and he lives in New Brunswick and all of Mr. Kratovil's reporting is false. And Mr. Kratovil's, or there was a press release that said, sorry,
There was a press release. I don't think that they said Mr. Kratovil's reporting was false because it's undisputed that Mr. Kratovil has not reported on this issue, number one. Number two, they did indicate the same thing that we've indicated on the record is that he had apartments in Middlesex County. He does live in Cape May, and that he's not a no-show, in the mayor's opinion, he was doing his job. He was not a no-show job.
Are you saying with regard to the interviewing of neighbors that there would need to be notice with regard to that specifically, as opposed to the notice that was provided in this case with regard to not publishing Caputo's specific address, but in the hypotheticals that Mr. Shalom discussed, that there would need to be some separate notice with regard to any other reporting that otherwise made his address available? I'm not sure.
In this particular case, if Mr. Kratovil went out tomorrow and talked to Director Caputo's neighbors, right? And they said he's either there, well, now he's there a lot because he's retired, but he's either there 5 days a week or he's there 1 day a week or whatever it is. And Mr. Kratovil utilized that with respect to his article. He can obtain, as long as he doesn't, I talk to people and it depends what he says. And this is where these hypotheticals run afoul. If he says, I spoke to X, Y, and Z in Cape May, I believe he can publish that because we have always said if Kratovil lives in, or Caputo lives in Cape May. If he says we talked to X, Y, and Z and they live at wink, wink, number 2, number 6, and number 8, X, Y, and Z Street, then it would be much easier for someone to figure out where Director Caputo lives, even after receiving that notification and figuring out where he lives after being notified and really flying in the face of Daniel's law. There's just different ways to do it. And I think that if he did it, I don't want to say the right way, but the more thoughtful way, where there is not a potential disclosure of Director Caputo's actual street address, actual street name. That complies, as I've said all along, with Daniel's law.
Do you
and with
take
the
the
opt-in.
position that there's never a situation for someone who's a covered person who's opted in, there's never a situation in which disclosure of the exact street address is constitutionally permissible?
I do not take that position. I think that if Director Caputo was selling drugs out of his house, I think if Director Caputo was taking some criminal action and the address of the house was directly concerning an issue of public importance, then I do think that that address could be.
So let's use your hypothetically selling drugs. This is all hypothetical. just to
Yes,
make
yes,
clear.
I
But
was trying to make sure it
who's
was.
covered by Daniel's law is selling drugs out of their house.
Yes,
Now you could make the same argument for that as you do with respect to his street address in this situation, which is the story of a public official selling drugs out of his house does not require everyone know what house it is. They don't have to go and look at the house to understand the seriousness of that situation. So I don't know how you distinguish respectfully between that setting and the setting of this case.
well, to me, if there is, let me just, to me, if there's an explanation with respect to, or a complete nexus with respect to the house and the criminal activities that is occurring there, and there's been case law on that, we briefed it. I do believe that that information has a direct nexus to the public interest and to the public dialogue. In this instance, the public dialogue has nothing to do with his actual address. It has to do with the distance.
But the selling drugs out of his house, if it happened, if it's alleged, if it's reported about, which house it is, if someone were to get in their car and drive around the city, the town, the whatever the town is not central to that story, is it?
It may be.
So
Again, it's very
I'm-
factually
but
sensitive.
But my suggestion to you is, if that's true, then what he is being accused of in this situation, which is living someplace that makes him a no-show employee, and I'm not saying he was or he wasn't, but that was the allegation here. It could arguably matter that where he was living is part of that story.
And where he was living was within the town of Cape May. Adding his house street number and street name has nothing to do with location, if you will, in terms of the 200 miles or whatever it is.
Then you get into the, and I think this is what Justice Patterson was asking. How is it a court's responsibility to decide, okay, in a newspaper article about a public official who's selling drugs, the house number is integral to the story, but in a newspaper article about a public official with a no-show job who doesn't live in the town that he is in theory serving, the street address is not relevant to the story without infringing on the First Amendment freedom of the press?
Because I think the court, again, based on the cases, look at content, form, and context, and determine whether or not it is related to or it serves an interest of the highest order.
So you
And
would concede that if a public official is accused of selling drugs out of their house, the house address is related to the subject of the story.
I would concede that it may be. It would
may
depend
be.
really what the circumstances are. I was
But
asked for a
if the
hypothetical.
wrongdoing, not illegality here, but wrongdoing that's being alleged is to be living in one place that makes it not feasible to get from point A to point B and work at the job that you're being paid for every day, then the location of that house is always going to be not related?
It would be immaterial in this case. I don't want, if there's other facts that in other cases, I don't want to address it, but in most instances, if the thrust of the argument is that Caputo is a no-show because of distance, providing a street address and a street number does nothing with respect to that analysis. It is, in the words of Judge Ray, superfluous.
So here I found the city's press release after the trial court dismissed the complaint, in which the press release said, quote, that Kratovil has tried to contend without factual support that Mr. Caputo has a no-show job, and that contentions raised by Mr. Kratovil in his lawsuit could not be further from the truth. And I think that your adversary's point was, in order to respond to that, and in order to explain why Mr. Kratovil does not believe that his allegations are not further from the truth, he needed to provide additional details. Again, where does a court decide? Yes, it's close enough. It's not close enough. The U.S. Supreme Court seems to take an extraordinarily broad view in Florida Star, where they don't even analyze whether the victim's name was necessary to the article. They just say the article is a matter of public concern. It's about a crime. Therefore, you cannot constitutionally punish the reporter for including the victim's name, even though we're not even going to say that the victim's name was necessary to the article or even relevant to the article.
So let me just back up for a minute. In this instance, the question becomes again, and I understand that the victim had that there was a statute, but in this instance, there is a highest interest of the order. And the idea is the firm of personal privacy in the home, the right to be left alone, as Justice Brandeis has said, and also with respect to the safety and security. So the question becomes, what if if publishing that street address and that street name, what does that add to that story? It does not refute, I think in terms of what your question is, it does not refute what you're saying that the city of New Brunswick has alleged in that press release. The press release specifically says the same thing that this case has said all the time, that he lives in a different town. It's X number of miles away, and that can be published. But adding that press release has nothing to do with saying he lives at 123 Main Street in New Brunswick, let's say, or 123 in East Brunswick.
But that appears to be conflating whether it's an issue of public concern with whether it is aimed at an interest of the highest order. When the Supreme Court in Florida Star analyzed whether this is an interest of public concern, they didn't consider what is the interest of the statute at all. That's a separate prong of the test. As far as I understand, there's 3 prongs. Is it a matter of public concern?
Right.
What is the state interest that the state is trying to advance? And is the statute narrowly tailored to that interest?
Correct. And your question has to do with
Public
interest,
concern.
public concern. And the question in terms of public concern is, again, dependent upon the facts. I understand what the Florida Star case said, but it has to do with, it had to do with a specific, the question of privacy really was an issue, came up. In this instance, again, it's privacy.
If we're talking about
It's
security, Florida Star represented a very significant threat to potentially an individual's security.
Because of
It's the home address of a sexual assault victim, which with a perpetrator still not apprehended,
Right.
Which could have put this individual in some immediate peril.
Yes,
And the court ruled that that was sufficiently related, or that the
Name of the victim.
Publication was sufficiently related to an interest of public concern, which was crime in general,
correct.
to get over that hurdle. So how do you get around Florida Star?
As I said, I think that the privacy in someone's home, it has been recognized in Doe versus Ports, which, as you know, is the Megan's Law concern. I think it is the people, there's a dog license case that this court has decided called Bosie. And with respect to the Bosie versus Jersey City, excuse me. And with respect to the dissent had indicated that it is, again, people's rights to have personal, private information protected, which was a dog licensing case.
But let me perhaps be a little clearer with my question. The Supreme Court was articulating the First Amendment standard,
Yes,
which binds all states. And the Supreme Court found that the First Amendment overrode or essentially granted the as-applied challenge to the statute that barred the publication of a sexual assault victim's address.
yes.
So how is it that would seem to me to be a more serious threat than is involved here, or at least arguably? How can we, bound by under the federal Constitution by Florida Star?
Yes.
What's your argument as to how this case is different?
Maybe I'm being inarticulate about this, but the case is different in terms of, with respect to how the court looked at it, and how the court looked at it with respect to, and I understand safety was an issue there, and safety obviously is an issue here, but here it is a personal home address, which this state has indicated is of the highest order, and the protection and safety of covered persons.
I have a question I've asked on the other side before about subsection A2 at the end, where not only is there, after notice is given, obligation of the party to stop disseminating it, but, and this is in the letter that was sent to the plaintiff on behalf of your clients, I hereby request that you cease the disclosure of such information and and remove the protected information from the internet or were otherwise made available. That removal language tracks the statute.
Absolutely.
We know in this case, at the city council meeting, the address was disclosed by the plaintiff. What are you seeking? What would you be seeking to have him do to comply with that part of the statute? If particularly the city council minutes or the meeting had been already made known to people outside of the folks in the room at that time, what practically does that obligation that you said in that letter had to be fulfilled? What does it involve?
So it's removed. So cease the disclosure of the information or remove the protected information from the internet or where otherwise made available. The letter came out obviously 12 days after that city council meeting. The city council, and I believe it's in the plaintiff's papers that the plaintiff attempted a request for the video, which was redacted because of that issue, providing that home address.
The video controlled by the city.
Correct.
But what if it, there's I think it's called patch.com, or there's a lot of ways that local events are already on the internet by people beyond the government agency itself. So what is the plaintiff supposed to do to remove it where the information is otherwise made available? It's already in the public domain, isn't it?
It is in the public. Well, I don't believe in this instance it went into the public domain. I do know that Mr. Kratovil had his own video recorder there. He, to my knowledge, because I looked for it, he hasn't published it. He simply asked New Brunswick for it. With respect to any other applications, I have not found that, and I've looked, number one. Number two, had there been in there, let's say the patch, for instance, if a letter went to the patch saying, please take that down because it shows protected information, that has nothing to do, if you will, with Mr. Kratovil, right? Because even though Mr. Kratovil divulged that information, it's the patch that would have to take that down.
So then if someone, I'm not suggesting it was true here, if someone were trying to avoid the consequences of the statute, they could immediately release it to the patch and other places that they can't control. And then, and after they receive a letter, well, I can't control these other places that are now broadcasting this all over society and essentially defeat the whole purposes of the statute, right?
Well, so it's interesting because if you look at subsection F of that statute, it says nothing herein shall be construed to impose liability on the news media for failure to remove information from previously printed newspapers, telephone directories, assistants, etc. So
I was wondering if somebody
before-
could avoid the statute
I
by doing
understand.
quick disclosure to disseminators that they can't control.
So the question actually becomes, had Mr. Kratovil received a letter before that city council meeting, I would suggest to this court that he would have not been able to put out into public the information with respect to Caputo's home address, or even supply the voter registration information to the city council people. He was not on notice at the time of that council meeting.
Yeah, but the word cease and then it's followed by remove suggests not only is there a prospective obligation to not disseminate anymore, but to take remedial steps about what you've already done.
There does seem to be that in A1, and as I've said, it seems to concern also subsection F, but I do believe that, assume that on May 4, Mr. Kratovil had published his article and he had named the street address and the street name. He didn't just say from Cape May to New Brunswick, right?
This is before the letter, right?
Because he did not receive the letter until May 15th.
Right, okay.
Right. So at that time, he was not notified, A, that Tony Caputo was a covered person, and B, that Daniel's law would apply. So in that instance, had he published that evening of the council meeting and had not received that opt-in letter, which is the prerequisite, I think that this case wouldn't be here.
He would have had no removal obligation.
It does say that to remove the protected information, under subsection 2, cease the disclosure and remove the protected information because it has to do with disclose, redisclose, publish, and republish. And so therefore, once that disclosure is made, to continue on the redisclosure. But as to your question, as to assume that it's picked up by every newspaper in the country, does that, Mr. Kratovil would have no ability to say to the Washington Post,
Right.
please take that down. Letters would then have, it would be a slog.
It would suffice for him to just take it down from his own blog or whatever you want to call it.
Correct, because obviously letters would have to go out to everyone, right? Washington Post, whoever else, to indicate that they need to take that down. And once they have that information, then they have the 10-day period where they have to make that decision as to what they're going to do.
You mentioned the Oprah provision regarding addresses. Was the clerk incorrect? I'm not saying any pejorative, but incorrect in interpreting Oprah to require the disclosure of this information?
So I will say this, I think, and it's nothing that this court, I'm sure, is not aware of, but Oprah requests are plentiful, bountiful. If there are certain periods of time that you have to answer it, if you do not answer within that time, there's obviously fines and attorney's fees and a lot of issues with respect to that. I think that clerks do their very best with
Understood.
respect to the
And of
influx.
course, the court deals with Oprah cases all the time and certainly
Yeah,
are aware of
That's
that.
why I'm saying.
But I want to
this.
get down to because another way in which this case would not have come to where we are today is if the address had not been disclosed in response to that Oprah
Correct.
request. So my question to you is really very precise, and I'm not blaming the clerk. I understand the pressures on the clerks, but was it an incorrect interpretation of Oprah to release that information?
I believe that the clerk did not abide by 4718-3. Yes. I believe that the clerk initially abided by that, but then had a colloquy with Mr. Kratovil and did not.
So what is your response to Mr. Shalom's assertion that better training of Oprah clerks, I assume specifically dealing with what goes on with addresses and also Daniel's law, is one way in which to make this case, if not unique, extraordinarily rare?
I think that I'm always in favor of better training people, number one. Number two, better training clerks, it still is not going to obviate the issue with respect to a mistaken belief in terms of turning over documents. Assume that the clerk, and I'm going to assume this, that the clerk knew of 4718-3 and forgot or just inadvertently disclosed that information. Better training isn't going to help that. There's always putting that onus on clerks who, as I said, are overworked, et cetera, putting that onus and that sole responsibility on that clerk. I think that particularly, I think it's a shared responsibility with respect to the personal addresses and the protection as indicated in Daniel's law. And that is based on the fact that it is because of a interest of the highest order. We know what happens when people find addresses and try to react with respect to those. Are there any other questions?
Any questions?
Thank you very much.
Thank you. Mr. Zuckerman.
Good afternoon, Your Honors. May it please the court. I want to dive right into the court's questions, but I'll just note in the colloquies this morning and this afternoon, I think there are some points of agreement between the Attorney General and Mr. Kratovil. They're also worth highlighting. First of all, it seems like all agree now this is just a question for courts. And I heard this morning that Mr. Kratovil is not contesting that this is a state interest of the highest order to the second Florida Star factor, and that there's some relational inquiry that courts should be doing to figure out whether something really is a matter of public concern. Now, I do think there is still hearty and sincere disagreement about how far the relational inquiry goes, whether it's met here and what happens on the third Florida Star prong or factor about the tailoring of Daniel's law here. So I want to dive right into those. And I think I just want to start with the case that's on everyone's mind, which is Florida Star, and the idea that there has to be some reasonable relationship between the thing that is a matter of public concern, that no one's disputing is a matter of public concern, and the specific fact that people are disagreeing about. So I will go directly to the line. It spans pages 536 and 537 in Florida Star, Justice Wehner, after that you pointed out that where the court does seem to take this, I read it as ambiguous, but there's certainly a broad statement that it's because it's in an article that is itself about a matter of public concern. There could be an implication. You could read that to say, well, they're just saying it's automatically in the force field of the matter of public concern because it's in the article. And I don't think that what they're doing there is making that broad reading. And I actually haven't heard Mr. Kratovil advance that either. Again, I think we agree there's a relational test. And I think it's because there is no other case that's actually read it that way, at least not one that I've seen and not one that Mr. Kratovil has identified. There were several Supreme Court cases before Florida Star that did a kind of relational inquiry, not precisely in the truthful matters of public concern area of doctrine, but as Judge Sabatino pointed out, in other places where the court has to figure out is something a matter of public concern or a matter of private concern. So you get that in the actual malice cases. You get it in the public employee speech cases. Connick versus Myers does an analysis that really would make no sense if you just get in the force field of public concern because you're inside a questionnaire that has something to do with public concern. We highlight in our brief Time Inc. versus Firestone, a case where someone is saying, well, it's a divorce case, but it's about the courts. The courts are a matter of public concern. I don't think Florida Star and Time versus Firestone can really both be right on that. One of them kind of has to be wrong if Florida Star, in that one sentence, is saying the really broad thing that I admit it could be read to say. So I don't think Florida Star is sub silentio overruling Firestone, overruling Connick versus Myers. And I think that's where Snyder is valuable, because Snyder comes back to the word relating to. It reaffirms there has to be some relationship. Again, we can quibble over how strong or weak that relationship has to be and how much deference you give to a journalist on it. But I do think both before and after Florida Star, the court has been pretty clear there does have to be a relationship. And that's how every other court that I've seen has read it. So I just want to commend to the court, actually, the cases that Mr. Kratovil himself cites. There's the Gilbert versus, I think it's medical economics case from the 10th Circuit. It says every private fact disclosed in an otherwise truthful, newsworthy publication must have some substantial relevance to a matter of legitimate public interest. He cited other cases. There's a case called Lowe from the 5th Circuit in 2007 that says it has to be substantially related. Again, he cites a case from Texas, Klinsman, it has to have a logical nexus. Again, I actually think we're agreeing that those are pretty good tests.
Let me ask you a little bit more precisely, because substantially related, what is substantially related to the area of public concern? I think the crux of this is, what is it? Is the fact that we're dealing with, in this case, the address, just have to be, as you referred to it, as in the force field, just because it's in the article, or does the fact that we're dealing with have to be related to the issue of public concern?
I think the fact has to be related to the issue of public concern. And I'll tell you why I think you get a precedent answer for that, and I'll give you a first principles answer for it too. I think precedent actually is pretty clear on that, not just the lower court cases that I just cited that Mr. Kratovil also cites. Again, I think we're agreeing those are fair tests. But if you look at Snyder versus Phelps itself, again, Justice Wayner, after I agree, there's the one line where they talk about the overall thrust of the protest, and they're talking there about two specific signs. One says you're going to hell, and I think the other one says God hates you. It's an abhorrent protest, but it's on a matter of public concern, the court says, and there's some ambiguity about those two specific ones, whether the protesters are talking about Mr. Snyder specifically and his family, or whether they're just sort of generally making a broad statement. I think the point the court is really making is that that should fall in with the broader statement, because it's too thin a reed to say that what they're doing in those two signs is singling out Mr. Snyder. Then on page 455 in Snyder, the court goes right to this question of whether or not the Westboro Baptist Church has effectively smuggled in an attack on the Snyders specifically. And they have a whole paragraph or two where they knock down that argument. And they say, well, this isn't a case where the matter of public concern is a stalking horse or a Trojan horse for the attack on the person. And that would be a different case. And I think that paragraph or two, whatever it is, only makes sense if you acknowledge that there is no force field that allows you to put something into the article that is not related to the matter of public concern. We give some examples in our brief that I think just have to be true, but let me go straight to Florida Star itself. And I want to make sure we're all crystal clear on that case, because it's very important. All that's at issue in that case is the name of the victim. That case is not a case about the address of the victim, and we have other laws. And we have other laws. I just to make really clear that although this particular as-applied challenge happens to be about Director Caputo's home address and Daniel's law, there are other laws too that protect against the addresses of victims of domestic violence, minors, victims of sexual assault. Ramirez is a great example. It collects many of these examples. They all, I think, make sense because of the constitutional significance of the home. But I don't read Florida Star to in any way say that because the name of the victim is inside the force field, which I think is debatable but fair, because the identity of a crime victim is somewhat closer to the fact of the crime.
Do you read Florida Star to stand for the proposition that because this individual was a crime victim, her name is related to the obvious issue of great public concern, and that is crime? Because that to me is suggested by the language.
I don't quite read it to go that far. Again, I think this gets to the question of how much weight can you put on that one sentence in Florida Star. And I take Florida Star.
The absence of any other analysis. So if it was that one sentence, but then there were several paragraphs that discussed why the name was so important to the crime in this particular case, or why a name is generally important to a crime, then I would completely agree with you. But the only thing they have that connects the name to anything is that one sentence.
I agree, Justice Wayner, but I think that what's telling is all the other space in that opinion that they're spending on all the other reasons that the newspaper, the Florida Star in the case, gets over the line and wins the case, which is all the other things that are going on in the three-factor test. There's this reliance interest. The newspaper got it from it was put in the press room, and therefore you're following, it conveys the message. They say this twice, actually, at 4:35, I think, and again.
The court even says, I mean, even if we were to read Florida Star to mean that, I can't remember the language you've been using, that, the victim's name is within this protected sphere, the court itself says that they're not saying that there isn't going to be a case, that there might not be a case with the appropriate facts in which imposing civil sanctions for the publication of a name of a victim might be so overwhelmingly necessary to advance the interests and satisfy Daily Mail. So even after having determined this is public interest, it's related to the concerns of crime and crime being committed, the court later says, well, we're not saying that there might not be a case with the appropriate facts, but here are all the reasons over the next several pages why in this particular case in Florida Star that they don't get over the hump.
I agree with that 100%, Justice Pierre-Louis, and they say this repeatedly in their cases. They say it again in Bartnicki versus Vopper. They cite all the other cases in Bartnicki versus, they collect them basically to say, look, we've always been incredibly fact-specific in these analyses. We've always sort of totaled everything up and seen which way it falls.
Let me give you a fact-specific hypothetical. that might help us understand the limits of all this. Could there be a situation where the precise street address is sufficiently related to the journalism that we would allow it to be disseminated? I was thinking of an example where, let's say, a judge who owns a home is sitting on a land use case involving an approval from some application that's only a few blocks from the judge's house. And someone is aware of that, and the judge, for whatever reason, I'm not suggesting any judges we know would do this, but it's not disqualifying the judge, right? So wouldn't in that instance the exact address where they want to show the public, look, this judge's house is only within a half a block or a block away from this development, the judge is sitting on the case. Wouldn't that be an instance where even if though the judge opted in and has the full protection of Daniel's law, we might say there's too much of a connection here? Would you agree that that would be an illustration where the First Amendment gives way here?
100%, Judge Sabatino. I think we gave this a very close cousin of that in our brief. We thought of two that sort of jumped out as situations where the First Amendment interest would be way, way stronger, where the nexus to the matter of public concern would be quite substantial. And so one is kind of shady land use deals or shady, arrangements involving the parcel itself. And then the second was where there's something dangerous about the parcel itself. So the neighbors have a fair interest in knowing, geez, that's happening on our block.
So you then would say a takeaway from this as applied case should not be, well, you never can post a home address. It only suffices to have the fact that that public official lives in that town. You agree that would be an overstatement or too broad a takeaway from what we're deciding here?
Absolutely, Judge Sabatino. I think all you need to say is that in this specific case, the nub of what Mr. Kratovil wants to report is that there's about 140 miles between where he supposedly lives and where his job is, and that's really far. It's not a case about the exact number of inches so that you can Google map to the west end of Cape May or the east end of Cape May, or where in the house his bedroom is, so you can really time it out to the millisecond how long it takes him to get there. The point is he lives about 2 hours away, and the town is relevant to that. Nobody's disputed that in this case, but that's, I think, all you need to say.
So what's your response to Mr. Kratovil's argument, and amicus echoes this, to what the trial court and appellate division did here was make judges into editors?
We disagree with that. We think that this is a question about how far the First Amendment applies. It's a question about what is a matter of public concern, which is something that affects, that is the question for figuring out how far, what speech is protected or not protected and how protected it is. That's a quintessential question for judges. Figure out what the First Amendment says, how it governs the facts of the case. Now, I understand that's not necessarily always a fun responsibility. Judges have hard jobs for lots of different reasons, even apart from the ones that motivated Daniel's law. Those are difficult judgment calls to make, but they're questions of law. The question is, what does the First Amendment say? How does it apply? Is this a matter of public concern or not? And there's just no way to do that analysis without thinking about what is this article about. The same way,
the requester cannot rely on the lay decision by the records custodian with confidence that, I can now publish it. I've lawfully obtained it. You reject that position.
We do. I mean, for a few reasons. One, I don't think you even need to get there, because here, again, Florida Star gets into all that once it's at prong 3, when it's past the post on a matter of public concern. It kind of says, well, all right, we've got something here on public concern. And then it goes into, well, they got it lawfully. Here, of course, we're not agreeing even that the precise street address, not the town, but the precise street address is a matter of public concern in the first place. But I do think when it comes to Daniel's law, it would be a mistake to let anything turn on the vicissitudes of what a particular Oprah custodian did or did not do. And if I could just take a minute to explain why, it's because of something that I think is actually quite tailored about Daniel's law, which is that it's an opt-in, kind of like a do not call registry. It doesn't take the sledgehammer of saying, no addresses, don't tell anyone about anyone's addresses. If it did that, it would be quite clear, and there would probably never be any mistakes, but it would be way more restrictive on speech. And I don't think that my friends on the other side, I think we might have a harder time defending a statute that took such a broad approach. I think by saying we're going to give the opt-out to the covered person and let them go to someone who's going to be distributing their address and say, hey, please knock it off. I'm investigating MS-13. I'm really, my family's getting threats. Please stop sharing this, and letting them then say, give them some time to comply. And if they don't do it, they're subject to civil damages. I think that's a very tailored regime, actually. And it means that there are going to be times, I don't know about this one, but where the Oprah custodian is correct to give out the address. And there are going to be times where the address comes from not an Oprah custodian at all, because someone got it from whitepages.com. And the person at that time may not even be covered. I mean, my mom has a dog. After Bozzy, someone could have gotten her address. Maybe tomorrow she's going to become a police officer. It's not a super likely hypothetical, but she's pretty tough. Then of course she might want to invoke Daniel's law if they put her on the gangs detail. But when someone got it lawfully from the records custodian in 2021, it was totally lawful. And it can't just be that the answer turns on the fact that my mom wasn't in a lockdown defense against her address her entire life just because she might become a police officer one day.
What's your response to Mr. Shalom's argument that the feds have a more narrowly tailored and therefore and constitutional version of Daniel's law because there's an exception for journalists, and the language?
I think it assumes the premise of the question. I think it just collapses into the dispute, the first dispute we're having, which is about whether this is a matter of public concern or not. I take that provision of Daniel's law to basically write in the Florida Star principle that we're all basically agreeing exists, which is that if something's a matter of public concern, then the scrutiny gets really hard. But we don't agree that you're even past that point. Writing in a provision like that is a nice thing for legislatures to do. It basically means you're never going to have as-applied challenges because you've made the as-applied challenge itself a kind of cause of action within the statute. But I think the answer to this as-applied challenge can't turn on whether or not the legislature had the foresight to say, hey, let's make sure we write a subdivision that says you can bring as-applied challenges for matters of public concern. It just reduces to the same thing that's happening here, which is in the rare instances where someone has an arguable claim that there's a matter of public concern. Again, we think misguided, but sincerely held. You get to bring an as-applied challenge. And I think, sure, a legislature could always write that in, and the Congress did in federal Daniel's law, but I don't think anything about this case can turn on it, because we would just be arguing that provision doesn't kick in here at all, because there is no matter of public concern, because 123 Main Street, as opposed to the name of the town, just isn't a matter of public concern on these specific facts.
You mentioned federal. Oh, go ahead, please. Yes, please.
You can argue that because the federal statute is prohibiting not only the street address and the home phone number, unlisted phone number, but also personal email address, social security number, bank account information, license plate number, full date of birth, etc. So some of those might implicate a matter of public concern in a way that you're saying the street address generally wouldn't in a case like this.
I guess two responses to that, Justice Weiner. I hope I'm understanding your question correctly. I think
it's just that the exception would have to apply to something. So if the statute only prevented the disclosure of a street address, and a street address is generally not a matter of public concern, I thought is what you were arguing, then there would be no exception. The statute wouldn't need the exception at all.
Well, sometimes, of course, the street address can be a matter of public concern. I mean, that gets back to my colloquy with Judge Sabatino, is that there will be cases where the parcel itself is part of the story. Again, Mr. Corrado in his brief cites, I counted 6 news articles. I'll note none of them actually give the street number. A couple give a street name or a block. And those are about kind of shady land use deals. They're exactly the kinds of things that we said would be a different analysis from a story that's just about the length of your commute from Cape May to New Brunswick, where whether it's the east end of town or the west end of town, just really no member of the community is making decisions about their life differently based on what the answer to that question is.
Since there is a federal statute, and we know there's a lot of other states that have adopted similar Daniel's law kinds of statutes, we were reminded that the complaint in this case was fashioned exclusively based on Article 1, Paragraph 6 of the New Jersey State Constitution. Are there jurisprudential or operational reasons for us to avoid extending any rights of the plaintiffs or other similar plaintiffs to have extra protection under the New Jersey Constitution because of the way that this statutory scheme on a nationwide basis has unfolded? Or is there potentially something unique about disclosures within New Jersey that require us to look more intensely at the claim that's being made?
Judge Sabatino, I'm not aware of any reason that you would go above the sort of general federal floor here. And I think actually, as an amicus, I wouldn't even be allowed to inject the argument that that the analysis is different. But I take the parties to have always agreed that you basically are doing the First Amendment analysis.
This was pled that way. You think the appropriate thing is to analyze it under federal law and see whether it comports or doesn't with the First Amendment.
I think that's right. If someone in the future wants to bring a claim and then brief up exactly why the New Jersey Constitution might require going hard, I mean, we would be happy to look at that, obviously, but we haven't studied it in depth because nobody's made it a centerpiece of this, or even not even a centerpiece, but really a part of this case at all.
Thank you.
Any questions?
Thank you, Your Honors.
Thank you. Mr. Shalom, rebuttal, please.
Thank you. Very briefly, I'd like to respond to 3 questions from the court and then 3 points made by my friends. Justice Wayner, after Ostergren v. Cuccinelli is found at 615 F. 3rd 263. It's a Fourth Circuit case from 2010, and it's cited in my brief. To the point that Mr. Zuckerman was just responding to you about, Judge Sabatino, we pled this case exclusively under Article 1, Paragraph 6, not under the federal Constitution, but we started from the premise that federal constitutional law, which of course is the kind of baseline of Article 1, Paragraph 6, is all that is required to address this case. So I agree with Mr. Zuckerman that we didn't ask the court to diverge in any meaningful way in this case, in any way in this case.
And you haven't identified any special reasons to do that?
Because we think federal law is so clearly in our favor, right?
Okay.
Justice Patterson, Pentagon Papers case talks about how prior restraints come with a heavy presumption against constitutionality, but I'll give you a New Jersey case. New Jersey State Chamber of Commerce versus New Jersey Election Law Enforcement Commission, which is found at 82 New Jersey 57. It's a 1980 case. And on page 70, the following: where a statute is challenged on First Amendment grounds, the traditional presumption in favor of constitutional validity is not available. So I think that's to Mr. Corrado's burden shifting. I also don't think this case is about force fields in any way. I don't think just because you are writing an article on a matter of public concern, you can throw in non sequiturs that have nothing to do with your article and then obtain the protection that the Daily Mail line provides. I also agree there is radical agreement on lots of things, as Mr. Zuckerman said. The problem is that fundamentally, my friends say that the address where he lives is not related to the distance between his home and his work. And that just falls apart on any inspection. It's a necessary element of it. Where you live is part, right? This is a distance from point A to point B. Where point A is related to. So again, if you use the trial court and the appellate division and my friend's suggestion of is it necessary, is it superfluous, then we might not win. You could argue, and I don't think it's right, but you could argue that it's not necessary. But you can't say that it's not related to the matter of public concern. And again, the only question is.
So what is your definition of a non sequitur?
I think this isn't my definition of a non sequitur.
I'm not saying for all purposes.
Right, but my definition of what
you're saying, you could come up with literally thousands of ridiculous additions to something on to an article on a particular topic, extraneous facts. You also have this one, which if this gentleman, and I am not saying he did or he didn't, but if he was not showing up for work, it's probably not critical whether he lived 162.7 miles away or 3.8 miles away, and that being the reason. You see what I'm saying?
Yeah, I do. And so let me
first aligned wrong.
I'm going to give you first a factual response and then a legal response. And the legal one is the one that carries the day. But the factual response is there's a lot of talk in the papers below about that the purpose of Mr. Kratovil's article was to talk about this no-show job. Go back to the complaint. It's not what it says in the complaint. That's not what it says in the complaint. The complaint talks about distance, and it talks about the finances of Director Caputo's multiple properties in Cape May. It talks about the deputy director's property. I'll direct you to paragraphs 13
I know,
and
it
14.
was the same building, et cetera, and all of that,
My point is, there's been this inference about what he wants to talk about that is actually not found in the complaint. This case was dismissed at the complaint stage, right? So there's that. But let me just answer very directly why I think we have to win here, Justice Patterson, and why it's not the non sequitur we're talking about. As long as the relationship between the contested fact and the agreed upon issue of public concern is as close as it was in the Florida Star, we win. If it's further afield from that, it doesn't mean we necessarily lose. Justice Wayner-Apter gave us a mechanism where we might not, but if it's within that sphere, if it's at least as close as the relationship between crime in general and a specific victim's name, then it's at least as related to as in that case. Okay. There was this, I'm going to just very, very briefly talk about the idea that the privilege for editors only applies to major conglomerates and not to smaller shops. I mean, that's totally foreign in our jurisprudence. Too Much Media v. Hale certainly rejects that. I'll direct you to Justice Powell's concurrence in Nebraska Press Association, where he talks about, I think it was the Anniston Star, but how small newspapers really are scared out of this. It's also a funny time to be saying that we can only give rights to giant newspapers, as we know that giant newspapers are no longer exist, right? So Mr. Kratovil's New Brunswick Today has been publishing for 14 years. It does not currently have a print edition, much like the Newark Star Ledger, right? And so that can't be the test. The lower court found that Mr. Kratovil is a journalist. My friends have not contested that. Mr. Kratovil is a journalist. And that gets to my last point, which is we had this talk about how much can he say and how many facts can he include and what level of detail can he go into to bolster his veracity. And Justice Wayner, after I had written down the two quotes that you read from the press release, that he said this without factual support and what he said could not be further from the truth. We live in dark times where the veracity of the press is questioned by lots of people with lots of power. And the press can no longer just assume that the public trusts them without the inclusion of details in the first instance. And it's those very details that would put Mr. Kratovil in jeopardy here. We asked the first court to reverse. Unless you had a question, Justice
I think I
Garrett.
do have one last question. It was something I discussed with Mr. Zuckerman. So you said if, and you rely heavily on Florida Star, if the relationship is as close as it was in Florida Star with regard to the name of the victim and the public concern, then you win. But as I was discussing when Mr. Zuckerman was arguing, the court itself in Florida Star further noted that even after determining that there was a public concern, noted that there might be a case, notwithstanding the relationship to the public concern, where the name of a victim could be so overwhelmingly, protecting that name could be so overwhelmingly necessary that civil sanctions could be imposed and it would meet the Daily Mail standard. So
that's right. And so first, let me start by saying the Daily Mail I'm sorry, not the Daily Mail. The Florida Star makes abundantly clear that it is deciding the case on its own facts. And that's because the newspaper's attorneys wanted a rule that said whenever you want to publish true information, you can't be punished. And the court said, no, we're not going that far. So the first threshold is does it relate to a matter of public concern? And that's the nub of this case. Does it relate to a matter of public concern? And I think when you actually look at what that means, concern, relate, it has to. But that doesn't mean it can never be.
Sorry, what did you said? I missed what you just said.
That we're not talking about a necessity test, but a relational test. Again, there is radical agreement as to that point. It is a relational test. It can't be totally foreign to it. But the question is, and I think my argument is the nexus must be at least as close, or arguably must be at least as close as it is in the Florida Star. the same factors that weigh heavily once you've made that threshold determination, I think also support us here in the narrow tailoring analysis. And frankly, I heard Mr. Zuckerman to essentially concede that point when he was asked about the exception in the federal law. He said, well, the exception in the federal law is all about whether it's a matter of public concern. And so he's right. If it's not a matter of public concern, we lose. But once it is related to a matter of public concern, it seems inescapable that for those two reasons, one, because the government itself handed it out, and we assume, and the Florida Star is extremely clear about how we do this analysis, when they give out the information, we have to assume that they had a better, more narrowly tailored way to prevent its dissemination rather than by criminalizing it and providing civil sanctions. So that's reason one. Reason two is the exception, and reason three is the criminal versus civil. I still urge you to reverse. Thank you.
Thank you, Mr. Schulman. Thanks to all counsel. This has been a superb argument on all sides. Much appreciated. Court's in recess for the day.
Thank you.